Good morning, ladies and gentlemen. My name is Jay Shankar from Malaysia External Trade Development Corporation, or MATRADE, the National Trade Promotion Agency. And I'm glad to be your host and moderator for the session today. Firstly, thank you for joining today's seminar on forced labor, the US, UK, and Australian perspective. This 2 hour session is organized by the Ministry of International Trade and Industry meeting with the support of the Ministry of Human Resource and Madrid. Our strategic partner for this event is the International Organization for Migration, IOM, while the media partner is the Star Media Group. For your kind information, this session is streamed live on StarBiz's Facebook page. So thank you to everyone who's tuning in right now. Do feel free to share our StarBiz FB Live with any of your colleagues or friends who are keen to join. All right, a few quick housekeeping matters before we begin. As everyone is dialing in to this webinar through various internet platforms and devices, you may or may not experience minor technical glitches. So please be patient if there are any. Now, to minimize the risk of technical glitches, all participants are muted, video cams turned off, and chat box disabled by default. For better listening experience, we would advise you to use your earphones or headsets. Also, very importantly, we would like to encourage you to participate by posting questions to our panel. You may send in your questions to our panelists at any time during the session. Now, you have two ways of doing this. If you're on Zoom, then click the Q&A button on your user panel. If you're accessing the session via FB Live, then post the questions in the comments section. Our team will do the needful. Now, there will be a short survey at the end so that those who are joining us through Zoom, please take a few minutes to complete it. Your opinion matters to us. Last, and more importantly, relax and enjoy the session. Now, a bit on the webinar itself. As we know, compliance with the labor policies, laws, and regulations of major importing countries of Malaysian merchandise, such as the United States, United Kingdom, and Australia, is essential for all exporters in Malaysia. As the economic frontliners of Malaysia, MITI feels it is of utmost importance for us to organize this seminar, which aims to guide Malaysian SMEs, especially those who are exporting to these countries and will have to consequently navigate through the labor framework of these importing countries. Now, we hope the webinar will be able to create awareness on the importance to adhere to these legal requirements, as it will go a long way to prevent restrictions, bans against your exports into those markets. Also, crucially, some of our speakers will also touch on ways to build the Malaysian manufacturers' capacities in dealing with restriction orders or ban on exports, if that ever happens. Now we have, it's a privilege, we have 4 esteemed speakers covering different aspects of the prevention and addressing of the forced labor in Malaysia. The 4 speakers are, we have Tuan Haji Muhammad Asri bin Abdul Wahab, the Deputy Director General, Operational Matters, and Encik Raimi bin Muhammad Ramli, Senior Assistant Director, the Enforcement Division of Anti-Trafficking in Persons Unit of Department of Labour, Peninsula Malaysia at the Ministry of Human Resource, both of whom will be giving the government's view on the subject. Now, this will be followed by Ms. Joanne Chua, the National Program Officer of International Organization of Migration, IOM, who will give us a presentation entitled Forced Labor, Regulatory Frameworks in the US, UK, and Australia. Now, our final 2 speakers will share experiences on dealing with forced labor law in Malaysia. The 2 speakers will be Mr. Matthew Thomas Phillip, the founder and managing partner of Thomas Phillip Advocates and Solicitors. He will be basically talking about WRP's journey in the lifting of the US WRO ban. Whereas Mr. Balan Shanmuganathan, the Senior Director of Sustainability at Seagate Technology Malaysia, he will be basically running through us the on forced labor supply chain expectations, especially from a principal perspective. But first, it is my utmost privilege. I would like to invite Yang Berbahagia Datuk Sri Nur Azman Ayub, the Deputy Secretary General, Industrial Development of Ministry of International Trade and Industry, MITI, to open today's session. Now, Datuk Sri Nur Azman Ayub has for the longest of time been a passionate advocate of matters related to forced labor and has often taken the lead in addressing these issues when formulating policies as well as planning and implementing industrial projects. Now, over to you, Datuk Sri Nur Azman. Thank you. Dato, I think you're on mute. You got to unmute yourself. Dato Sri Nur Azman. There you go.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, Salam Sejahtera. First and foremost, I would like to welcome all of you to this morning's webinar organized by MITI in collaboration with the International Organization for Migration, the United Nations Agency, our very own Malaysian External Trade Development Corporation, and the trusted media partner, the Star Media Group. I would also like to express on behalf of MITI our appreciation to our esteemed speakers from the International Organization for Migration, Department of Labour Malaysia, Thomas Phillips Advocates and Solicitors, and Seagate Technology. Ladies and gentlemen, the international trade landscape has been characterized by several challenges in the past few years, such as the trade tension between two of the world's largest economies, growing trade protectionism amongst trading nations, and of course, this year, the outbreak of the COVID-19 pandemic that has battered economies around the world. On the domestic front, while our industries and businesses are slowly recovering from the impact of the pandemic, the intermittent surge in COVID-19 clusters, especially amongst the industries, has raised an equally growing concern in relation to labor or workers' rights. Of late, the issue of workers' rights has been in the headlines as far as Malaysia is concerned, impacting the business operations of our companies, not only in Malaysia, but in the international markets of which they serve, particularly in the US and Europe. The US, for example, through the US Customs and Border Protection, has issued withhold release orders or restrictions on the export of certain goods from Malaysia that has caused loss in revenue to the companies concerned, as well as impaired their reputation. From an investment point of view, institutional investors and fund managers are increasingly seeking companies that adopt environmental, social, and governance elements, or commonly known as ESG, in their business strategies or operations. The social aspect of ESG is associated with having good labor practices. There are at least three reasons as to why companies will need to pay attention to having good labor practices. The first reason would be market access. Now, if you plan to enhance your access to international markets, particularly in the developed markets, you need to adhere to high standards in terms of labor protection. Allow me to relate to you a story of how an American retail chain that recently came over to Malaysia to inspect the quality of products produced by a reputable Malaysian company. Now, at the end of the visit, the American retail chain representatives were treated to a dinner. During the course of the dinner, they asked questions pertaining to labor protection, as well as the living conditions of the workers of the Malaysian company. The American representatives informed that even though the products produced by the Malaysian company would have met the highest standards in terms of quality, but if the Malaysian company failed in terms of providing adequate labor protection to their workers, they would not be able to become part of the supply chain of that American retail chain. The second reason would be cost to your business. Now, if you're seeking to expand your business, you may run the risk of not able to secure investments, particularly from institutional investors, that increasingly place emphasis on compliance to the ESG. As to the final and third reason, if you are a small and medium enterprise, your continued integration to the regional and global supply chain may be at risk, since your customer or the principal company of which you are supplying to would demand such compliance, especially if they themselves are supplying to markets whose customers are equally informed and demanding as far as labor protection is concerned. Hence, MITI has taken the initiative to provide guidance and to share knowledge with Malaysian businesses, particularly the manufacturing sector, as well as the SMEs, on the laws and regulation relating to labor protection, labor rights and practices, not only in Malaysia, but as well in other international markets. Hence, the organization of this morning's webinar. Series of outreach sessions have been planned, with the first held in July this year on labor standards compliance to ensure a sustainable supply chain. Now, that session was held to update on recent laws and regulations, particularly on the minimum standards of housing, accommodation, and Employee Facilities Act, or what is now popularly known as Act 446. Ladies and gentlemen, the government is taking a holistic approach and view towards managing and addressing issues related to labor rights, practices, and allegations of forced labor. Apart from creating awareness and knowledge sharing, in terms of enforcement, the Department of Labor has started to initiate legal actions against companies which fail to comply with the Act 446. The Malaysian government is aware and equally concerned about the restrictions placed by governments in other countries on shipment of Malaysian goods to their markets due to alleged violations of labor protection as well as forced labor elements. Now, the knock-on effect of such actions would be to the whole industry in terms of reputational risk. While businesses seek to lower production costs or improve the quality products, it is imperative to maintain confidence of consumers who are informed of unethical labor practices or below minimum standards by companies. Therefore, the government is committed to promote ethical recruitment or labor practices that would adhere to international standards to curb further forced labor allegations that have serious ramifications to the country's reputation, as well as negatively impact our domestic industry's integration into the regional and global supply chain. MITI will continuously engage with our industry stakeholders in order for them to be aware of the latest updates with regards to laws and regulations, and for us as a government to understand the challenges faced by them in complying with the required laws and regulations, and how we as a government can help them to address these challenges. Ladies and gentlemen, I would also like to encourage our industries to adopt automation and digitalization in your manufacturing processes to the various support mechanisms and initiatives offered by the government. In closing, I want to say that the commitment by the government alone would not be adequate and sufficient. We encourage more industry associations as well as individual companies to come forward to work closely with us, the government, in ensuring compliance to the required labor standards to eliminate forced labor elements in our supply chain. I thank you for your attention.
Thank you, Yang Berbahagia Datuk Sri Nur Azman Ayub. As usual, you have been very insightful. Now, our first speaker for today would be Tuan Haji Muhammad Asri bin Abdul Wahab. Tuan Haji holds a Bachelor of Economics and Analysis from University Malaya. He began his career as a labor officer at the Department of Labor, Peninsula Malaysia, and after many years of experience as director in multiple branches in Selangor, Kuala Lumpur, and also at Labor Standards, he is currently the Deputy Director General, Operational, Department of Labor, Peninsula Malaysia at Ministry of Human Resource. Without further ado, please welcome Tuan Haji Asri bin Abdul Wahab.
Assalamualaikum warahmatullahi wabarakatuh, and very good morning to Yang Berbahagia Datuk Seri and all of participants. I will take this opportunity to, on behalf of Ministry of Human Resource, Executive of the Department of Peninsular Labour of Peninsular Malaysia, to thanks the Ministry of International Trade and Industry for kindly hosting and inviting me and my team to join in this webinar. I was made to understand that this webinar is an extension of the various efforts done by other ministry and agency to support strong compliance with the labor law among Malaysian companies. In recent years, the Malaysian government has shown increasing interested in carrying of the initiative leading toward greatest compliance with the international obligation on trafficking and forced labor. Most visible through is effort against trafficking in persons. In the mind of COVID-19 pandemics, enforcement of Act 446 will start on 1st September 2020 has set the requirement for the employer and centralized information provided to obtain a certificate of accommodation from the Department of Labour Peninsular Malaysia. Since 1st September 2020, the JTKSM headquarters and the State Department of Labour have implemented comprehensive enforcement to ensure that employer and the CLQ are centrally comply with the acts. Enforcement operation are carried out personally during the September, the end of October. JTKSM and JTK Negeri conducted 1,322 enforcement and inspection activities throughout Peninsular Malaysia. This enforcement included 1,305 employer and as well as 17 centralized accommodation provider. MOHR also play a role in combating human trafficking among the country labor industry community. Enforcement activities carried out of the collaboration with the relevant agency are also carried out the continuous, and this show that the ministry is not comprising of the issue of forced labor as well as human trafficking. In fact, for this year 2000, a total of 19 inspection activities under the ATISOM integrated operational involving agencies such as MAPO, JKKP, PDRM, KKM, MITI, and also SOCSO, which conducted throughout the country. We hope that the enforcement of the amendment, including the new rule, the regulated standard of housing and workers facility, will prevent the spread of the COVID-19 pandemic, which is the line with the International Labour Organization Recommendation 115, Workers Housing Recommendation 1961. So now I invite Mr. Rami to continue this presentation. Mr. Rami.
Thank you, Tuan Haji Asri. As he indicated, we would like to now kindly invite Encik Raimi bin Muhammad Ramli, the Senior Assistant Director attached to the Enforcement Division Anti-Trafficking in Persons ATIP Unit in the Department of Labour Peninsular Malaysia in Putrajaya. Encik Raimi holds a degree in law from International Islamic University of Malaysia. He was admitted as an advocate and solicitor in the Malaysian Bar in 2000. He practiced as an advocate solicitor prior to joining the Industrial Relations Services in 2002 and held the post and currently holds the post of Assistant Director of Labour. Let's welcome Encik Raimi. Thank you, sir.
Okay, thank you, Mr. Moderator, and thank you, Tuan Haji Asri, for the opening remark. Ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Very good morning. Uh, Thank you for the opportunity of inviting the Labour Department and the Ministry of Human Resources in sharing information and knowledge in issues regarding to indicators of forced labor. And our slides for today is on the indicators of forced labor. And because that we are currently progressively enforcing Act 446 in relates to the housing and accommodation of workers, the emphasis of the presentation would be more, or emphasis is on the non-conducive accommodation issues. So, ladies and gentlemen, I would like you to refer to my presentation. So, for the next slide, please. Okay, ladies and gentlemen, in combating forced labor, in the current Malaysian perspective, the combating of forced labor is within the ambit of the Anti-Trafficking in Person Act. So the Act provides five agencies, currently five agencies under Section 27 of the ATIPSOM, which comprises of the Royal Malaysian Police, Immigration Department, Customs, the Maritime Agency, and also the Department of Labour, comprising of Peninsula, Sabah, and Sarawak. So specifically, the Labour Department plays a vital role in the issue of forced labor. And in terms of enforcement, not just enforcement for the purpose of ATISOM, even under our labor inspection, okay, we include the indicators within our inspection checklist, okay, to determine whether they are practices or indicators of forced labor. Okay. These indicators of forced labor are indicators which may relate to issue of forced labor, where the issue of forced labor need to be defined as forced labor which the workers work involuntarily, and the workers been instructed to work due to fear of menace of penalty. So the indicators must link to these issues. Or sometimes the issues of indicator also may also relate to ill treatment of workers. Even though it's ill treatment of workers, it's not acceptable. Okay, and due to the fact that the awareness pertaining to workers' rights are very important, especially in the developed countries. So we must ensure that our produce does not have any form of forced labor indicators. As you can see from the slide, there are about 12, I believe, forced labor indicators. Okay, one of it is abuse of vulnerability, which states about the misuse of the vulnerabilities of the victims. Okay, to ensure the workers to abide, or the suspect, or the what we call the victim, okay, to abide to the trafficker or to the perpetrator. Secondly is by using the method of withholding of wages. Okay, so by withholding of wages, to ensure that the victim will always be with the perpetrator. Okay, because they need to wait for the wages to be paid. So this is obviously contrary to even the normal labor legislation under the Employment Act 1955, particularly under Section 19, which provides the manner of how the wage should be paid, okay, the period whereby the wages should be paid. Secondly, the issue which always been alleged even by the international spectators is the passport retention. Okay, this is something which is not allowed, as passport retention also would relate to restrain of movement and isolation. So basically, currently, we do not condone any passport retention, as it can violate not just in terms of the forced labor indicators, it will also relate to offenses under the Passport Act. Okay, so please bear in mind, ladies and gentlemen, we no longer can accept passport retention, as passport retention, as you can see, is one of the indicators of forced labor. So please ensure that your workers keep their passport, or have a systematic way by way they can obtain their passport at any time, because obviously the passport is issued by their own respective government. So we do not in any way have the right to hold unless for the purpose of processing or any matters related to the employment of the workers. After that, you need to give it back to the workers. Okay. So please take this, please take note of this issue. Restraint of movement, as I've mentioned, is related to the it can relate to passport retention. You cannot restrain the movement. Restraining of movement only can be done during working hours. Okay, so Section 60A has provided working hours is for purpose of work issues, working matters. After the working hours, the workers are free to use the time for their own needs. Okay, you cannot isolate their workers, and you cannot restrain their workers in terms of using non-working hours for their own private purpose. But obviously, due to COVID-19, you need to remind the workers to ensure no direct contact and no close socializing. And in fact, the issue of social distancing, you must ensure that social distancing is also there within the workplace due to COVID-19. Okay. The issue of deception, okay, deception can happen when the workers been recruited. Okay, for instance, they've been recruited, let's say that they've been offered to work in manufacturing as what we call as the operator, production operator. But when they arrive in Malaysia, they do not work as an operator, but they've been sent to be a harvester in the plantation. So this would be a form of deception. We have come across this kind of cases. Okay, debt bondage. Okay, the allegation of debt bondage, whereby the workers need to settle off the debt, and this debt is related to employment. Okay, currently issues of debt bondage also relates to recruitment, issues of fair recruitment, where when they are in the source country, the workers been asked to pay certain amount of payment which is not been included for the purpose of employment. So this would in a way can relate to issues of debt, whereby they need to settle off this debt which they incurred in the source country, and this thing also need to be looked into. You need to check your suppliers, your recruiters. Maybe there is this is a high time for the employers to make some form of what we call as due diligence exercise to ensure that these recruiters are not taking advantage of these workers. Okay, because at the end, the employers will be accused of uh, of uh, getting involved with the issue of debt bondage. Okay, intimidation and threat, whereby the workers are intimidated. If you do not work, then you will suffer something. Okay, physical threat, and this also would relate to the issues of abuse. Okay, excessive working hours. Okay, in our current law, obviously the working hours cannot be more than 8 hours. That would be the normal hours, but you may require the workers to work more, but not more than 12 hours per day. That is inclusive of the overtime. And the current law provides that permits for you to require them to work more than the normal hours of work, subject that they've been paid accordingly. They've been paid the payment for overtime, payment working during rest day, payment, public holidays, so on and so forth, in accordance with the calculation and the formula as provided under the Employment Act, particularly the compliance of the ordinary rate of pay under Section 60I. So based on inspection we conducted, there are some employers which fail to comply to the ordinary rate of pay for the purpose of the payment of this overtime, public holiday pay, and working during rest day. Okay, that would be another issue, but excessive working hours without adequate pay also would be one form of forced labor indicators. And the emphasis for today is non-conducive accommodation, has been kindly pointed out by Tuan Haji Asri pertaining to the ILO convention, the need for us, Malaysia, to follow to ensure that the standard is in accordance with the standards of as provided under the international convention. So for this, can we move on to the next slide? Okay. So the Minimum Standards Housing Accommodation and Amenities Act is actually an act which has been in our jurisdiction since 1990. Basically, at first it covers plantation, but due to the issues of accommodation outside of the plantation, it has been amended. So the amendment has been effective since 1st of June, and the full enforcement is 1st of September 2020. Okay. So the objective of the provision of this act is that to ensure the minimum standard of accommodation and facility which is provided by the employer, and within the current issue, within the current situation, looks like that the issue would cater the issues of migrant workers, since the bulk of migrant workers are within the manufacturing sector. Okay. And application of the act to all sectors of employment. Right? So this is actually a new improvement of the law. Welfare, safety, health of the employee, and the act has been amended, as I mentioned, to comply with the international standard under the International Labour Organization. So application of this law, okay, it is compulsory for employers who provide employees accommodation, and another part is those who provide centralized accommodation providers, or we call it as CLQ. CLQ are those companies or entity which provide centralized accommodation providers for employers. So these employers, they do not provide their own, but they provide their workers accommodation which is managed by centralized accommodation provider. Okay. Currently, application of this law is throughout Peninsular Malaysia and the Federal Territory of Sabah. Okay. And then the sentence, the offences and sentencing is quite serious. Okay. Failure to have a certificate, fine of not more than 5,000, and imprisonment not exceeding 1 year or both. I'm sorry, not 5,000, 50,000. Okay, so you can, if you look at the amount of punishment, the fine imposed, it shows the seriousness of the government in issues pertaining to the housing and accommodation. Violation of other provision, fine not exceeding 50,000 or daily fine not exceeding 1,000. So you can imagine daily fine is 1,000 ringgit for non-compliance. So meaning that first you've been fined, let's say that 20,000, and then subsequent daily fine of 1,000 ringgit. So please bear in mind, ladies and gentlemen, this is very serious. Failure to report employee occupation, fine not exceeding 10,000 ringgit. Okay. So it is hoped that with this act that the improvement of housing can be better than the previous situation. Next slide. Okay. I just want to touch on the dialogue that we had in the United Nations Malaysian Policy Dialogue, protecting the rights of migrant workers, which has been held on the 26th of November. One of the issue which is agreed that Malaysia currently still rely and there is a need for migrant workers. Okay, so due to that, the suggestion is that we need, especially the employer needs to improve the accommodation of for all of their foreign or migrant workers, and the Department of Labor in terms of ensuring the employers providing suitable accommodation, conducted inspection for certification accommodation, and in order to ensure the full compliance. Okay, next slide. Next slide, please. Okay. This would be the workers' accommodation statistic. Currently, we have about 1,082 applications as of 13th of December 2020. Okay, but I need to mention that the number of application is still low. So please, ladies and gentlemen, please ensure that the companies, okay, which provide accommodation to submit their application. Okay. All right. So this would comprise employers about 996, and for the accommodation centers or the CLQ is 86. So this would involve 5,801 accommodation, which provide the capacity of 247,617 capacity of accommodation. Okay, but as I mentioned, that the application is still low, right? So there is a need for employers to ensure that they apply. Okay. Secondly, on the application, 6 higher state. The first one would be Selangor, 338. Secondly, Johor, 199. Then we have Penang, 160. For Perak, 151 application. Melaka, 74. And lastly, Negeri Sembilan, 61 application. This is for 6 higher state which the employers submit their application. And then we look into application by sector. Okay, manufacturing would be the biggest submission of application. Okay, this is something which is very good. Okay, good for the manufacturing because they would be the highest number currently, 746 application. Then we have the services, 283. Next, the third one, construction at 27 application, agriculture 24, and others. Others meaning other sectors, which is not within the 5 major sectors, 3. In terms of enforcement, which has been conducted as of 13th of December, we have conducted 1,608, 1,608 inspection, and from that 576 operation of the 446 Act, okay, throughout Peninsular Malaysia, and 280 follow-up application, meaning that we do follow up from application submitted by the employers. And enforcement by sectors, okay, the highest would be manufacturing, and the second place, services. Third would be agriculture, others, and the last one would be construction. And the serious part is investigation. Okay, offenses. Okay, there are 3 type of offenses which investigation papers has been opened and submitted. Okay, 19 on failure to obtain certificate of accommodation. Okay, and then we have 3 failure to comply with local government condition, meaning to build or to prepare accommodation. Okay, and thirdly, failure to comply with regulation as per regulation under the 446 Act. We have 3. So we currently have 25 investigation papers which has been opened up. Okay, next slide. Okay, this would be the action plan in terms of accommodation. Okay, first would be the inspection, as this would be the core activity of the Labour Department. Okay, inspection on employers with foreign workers as under Act 446, which I mentioned earlier pertaining to the inspections. okay, and also the operation which has been conducted. Secondly, technical committee. Okay, this technical committee is on the headquarters level, comprising of industries, namely rubber, plantation services, which includes restaurant and cleaning services, then the electrical and electronic, E&E, and then furniture, and lastly, construction. Okay. Thirdly, the action plan would include the communication plan, mass media, engagement session, and roadshow. So currently, we do engage media in terms of getting the information through, okay? And also, fourthly, the cooperation with SOCSO and the Department of Immigration pertaining to the application and coordinating employees' information. Okay, so in that we do interagency cooperation, because as we know that we need to check also the application or the numbers, okay, record based on SOCSO and record based on the Department of Immigration. The fifth action plan, inspection, Act 446, which focusing on accommodation, okay, and inspection on December, January, and February 2021. We are in full swing currently, commencing from December, January, and February 2021. We can say that every day we are going for inspection, okay. And task force, okay, this is particularly for the purpose of issuing issues of anti-trafficking, exploitation of forced labor, whereby the formation of task force for forced labor and child labor. Okay, we have divided into 4 zones and focusing on vulnerable sector. Okay, so vulnerable sector could be manufacturing, plantation, okay, construction. All right. So those would be sectors which we will look into. Okay, next slide. Okay, these are some of example of accommodation, good accommodation, which comply with Act 446. Okay, next slide. Okay, okay, this one would be the non-conducive accommodation. So this would be one of the bad examples. Okay, so we do not want this afterwards. Next slide. Okay, as you can see that it is non-conducive. Okay, next slide, please. Okay, so before I end my my presentation, I would like to share some newspaper reports yesterday on the inspection, whereby I just want to quote several newspaper report. 322 workers are crammed within a hostel which is filthy and also with clogged toilet. And then there is another newspaper clipping saying that the workers' accommodation is very cramped and as if as a tin sardine, okay, like a can of sardine. And the third one, this one is very interesting, as if the workers are being housed in a chicken coop. Okay, so these are serious remarks, ladies and gentlemen. This would not reflect well, okay, for not just for the employers, but also for the country as a whole. So please, I implore you to ensure that you comply with the law, you comply with the basic necessity as provided under the Act 446, and take note that we are we are actively enforcing the law to ensure the workers are being treated fairly, because at the end of the day, we need the workers to be treated decently, as we already agreed. The country has already agreed with the decent work agenda. So without providing workers with adequate or conducive accommodation, we cannot fulfill the decent work agenda. So thank you, ladies and gentlemen. So I pass it to the moderator for the deliberation. Thank you once again.
Thank you very much, Tuan Haji Asri and Encik Raimi for that presentation. It is certainly an eye-opener. Some of the visuals there could also be very indicative of the situation on the ground. So again, thank you very much for that excellent presentation. Now, our second speaker is Ms. Joanne Chua. So she was a lawyer with a leading human rights and criminal defense law firm in Malaysia, where she conducted complex and sensitive criminal, civil, and human rights cases, including in the areas of human trafficking and forced labor. She is now currently the National Program Officer for Counter Trafficking and Labor Migration with IOM, which is a UN migration agency. She's also involved in labor migration lead and heads the CREST, Corporate Responsibility in Eliminating Slavery and Trafficking Initiative, and IRIS, the International Recruitment Integrity System programs in Malaysia. She develops, manages, and implements programs with the private sector and the government of Malaysia with a focus on identifying and addressing issues of forced labor and exploitation in international supply chains. This includes leading risk assessments, conducting capacity building workshops, and developing policies relating to the recruitment and employment of migrant workers in counter trafficking. With that, let's now welcome Ms. Joanne Chua. Joanne, the floor is yours. Thank you.
Hi everyone. Thank you so much. Let me just give me a moment to share my screen. Can you see my screen? Okay. Yes, no. Can we see it? I have. Right, thank you. So as Mr. Jai had introduced, my name is Joanne and I'm the National Program Officer with the International Organization for Migration. IOM is the United Nations Migration Agency. So before I move on to the main presentation, I'll just give you a brief introduction as to who we are. IOM is headquartered in Geneva, but we have 4 offices in Malaysia. IOM has 174 member states. These are governments, and 9 observer states, one of which is Malaysia, with 590 offices in over 100 countries. IOM is committed to the principle that humane and orderly migration benefits migrants and society. So born in 1951 out of the displacement of World War II, IOM came into being because we were mandated to essentially move the people who were displaced due to World War II. IOM is very much a boots on the ground organization that has now also moved into policy. Here on the screen, before we move on to the forced labor regulatory frameworks, let's just go through what modern slavery is. So modern slavery is essentially an umbrella term that covers forced labor, forced marriages, human trafficking. The common thread here is that a person who is being exploited and cannot refuse or leave due to threats, violence, coercion, deception, manipulation, and or abuse of power. So here you can see on the screen, globally, there are 25 million people in situations of forced labor. That is out of 40.3 million victims of modern slavery. 16 million of these victims of forced labor are working in the private sector, and 50% of them are currently in debt bondage. So what debt bondage means is they pay a huge amount of sum as recruitment fees in order to get a job in Malaysia. So for example, a worker may pay up to 30,000 ringgit Malaysia to get a minimum wage job in Malaysia. So it takes them almost 3 years to just repay that debt. This is the highest prevalence in Asia and the Pacific, where 4 out of 1,000 people are in this situation. 1/4 of these victims of forced labor are international migrant workers, and forced labor in the private economy generates 150 billion US dollars in illegal profits every year. I won't go through these again because Encik Raimi has covered them very thoroughly. So there are 11 ILO forced labor indicators, and this is what the governments in the UK, US, and Australia look at in determining whether there is forced labor in your supply chains. So the presence of any one of these indicators may in itself result in forced labor, or it may take a combination of more than one of these indicators. This really depends on the situation or the factual matrix. And businesses should work towards eliminating all of these indicators from your operations and supply chains in order to ensure that you're legally compliant. So we know that these acts currently are not in Malaysia. We are talking about the US, we're talking about the UK and Australia. So why should Malaysian businesses care? So we know that the US, UK and Australia are major importing nations. A lot of Malaysian businesses, including SMEs, export to these countries. And now there's increased attention to Malaysia. We can see the news about the CBP bans and things like that in the industries of palm oil and rubber gloves. Malaysian businesses that supply or export to the US, UK, and Australia should be prepared to comply with reporting requirements and requests for information. So I'll go into this in a little bit more detail in the following slides. But what we need to know is that we need to protect workers' rights in line with international standards in order to prevent legal, financial, and reputational risks. So by legal risk, we mean to protect yourself against legal action that is taken by the authorities, by your stakeholders, or victims based on modern slavery, trafficking, and forced labor laws. Because in Malaysia itself, we already have some laws which prevent this. So you don't want to be on the other side of a court case either. Financial risk. So financial risk could mean any financial loss that is suffered due to having to remediate the workers, paying fines, damages, or suffer contract termination by your customers, by your buyers or business partners as a result of your unethical business practices. And reputational risk. You can just open any newspaper now and you often see news reported about how migrant workers are treated in Malaysia. So we've been seeing a lot of negative press in the media. This, as we can see, has led to loss of both market share and profits due to the public, buyers, or investors not choosing your business for ethical reasons based on what they have found out from the media, from the CBP bans, or even civil society reports. So it is important for businesses in Malaysia to strengthen labor conditions in order for you to generate more business opportunities. A company with integrity will create higher demand and the productivity increases when the workers are cared for. Right, so here on the map are the 3 countries that we are covering today. We have the United States, the United Kingdom, and Australia. So let's go to the United States first. So United States has federal level law to specifically restrict imports produced with forced labor. That would be the US Tariff Law of 1930 and the Trade Facilitation and Trade Enforcement Act of 2015. So this is the US CBP, the Custom, Border and Protection that we have been seeing so much in the media. And secondly, we're also covering very briefly a state level law, which is in California. It is the California Transparency in Supply Chains Act 2010, which requires disclosures. So why we are also including California here is California is actually one of the pioneer states in the world to enact law requiring disclosures relating to modern slavery in supply chains and operations. So it was this Californian law that provided the precedent for the UK and Australian Modern Slavery Acts. A similar disclosure law is also being developed in New York and is currently going through the legislative process, but there's little information about that as of now. So let's move to the UK. So the UK, we have the Modern Slavery Act of 2015. What it requires is reporting requirements. And for Australia, we have the Modern Slavery Act 2018. So the Modern Slavery Act in Australia is newer. And for Australia, this is actually the first year in which businesses will now have to make disclosures under the law. So I'll cover these two countries together because they are both similar acts that requires reporting. What must be reported or disclosed for each country can be quite different based on the legal requirements. However, there are some companies that choose to make a single disclosure statement covering all jurisdictions. So for example, instead of making 3 different reports, one for the UK, one for Australia, and one for the US. What they do is they release one statement which covers all 3 countries. So how they do this is generally by disclosing more information than what is needed by one specific country under the respective legal requirements of each jurisdiction. So how the UK and the Australia Act differs from the US is that there are currently no specific regulations in the UK and Australia that aims to restrict imports produced with forced labor or modern slavery, which is similar to the CBP enforcement laws in the US. So to give you an overview of this the purpose, before we move into each law in depth, you can see here on the screen. So the purpose of these modern slavery laws are to drive corporate action, to look into their supply chains and work conditions in order to eradicate modern slavery, forced labor, and child labor within those supply chains. It also, it also encourages active supplier engagement, and it requires the companies to clearly and consistently communicate expectations to suppliers. So you are the suppliers, and may even require supplier responsibility in contracts. So I'll explain what this means in the following slides. So most of the laws here require reporting, and this encourages transparency. It also empowers consumers and investors to choose ethical businesses, and it raises awareness within businesses, as these laws require the top management to sign off on reporting. So what this means is that, for example, if a director has to sign off on the report, he can't say that, oh, I wasn't aware that this was happening in my company, because now he has to also be accountable and take responsibility for that. And here, it also allows consumers and civil society to hold these businesses accountable through advocacy based on this information which has been provided publicly. And of course, the general overarching purpose here is in order to bring about business responsibility in upholding human and labor rights in line with the UNGPs, the UN Guiding Principles, and the Sustainable Development Goals. So earlier I mentioned supplier responsibility in contract. So what this means is that moving forward, your buyers may have clauses in the contracts which require you to allow them to conduct, for example, external audits, annual reporting, and things like that. So firstly, we will look at the US legal framework. If I'm going a little bit too quickly, please feel free to prompt me in the chat box, yeah? So for the US, this is the US legal framework introduction to the 2 relevant laws. So we'll go to the federal law first. So the federal law, as I mentioned just now, the main one would be the US Tariff Act of 1930. So this is what empowers the CBP to detain and seize merchandise which has been produced with modern slavery or forced labor. And this is enforced by the US Customs and Border Protection. And the second one here, which we mentioned briefly earlier as well, is the California Transparency in Supply Chains Act 2010. So the California Transparency in Supply Chains Act 2010 requires public disclosure, and this public disclosure can be enforced by the Attorney General injunction. So what this means is, for example, if the company does not want to disclose, then the Attorney General can take the company to court to force them to make that disclosure. And more than that, it is perhaps also useful to note here that the US Department of Homeland Security has also made forced labor a priority area in their strategic plan for 2020 to 2024. So what this means for the rest of us is an increased enforcement in modern slavery and forced labor. CBP enforcement. So this is the one that we've been seeing so much in the media. So CBP enforcement is governed by the US Tariff Act of 1930. And forced labor here is defined as all work or service which is exacted from any person under the menace of any penalty for its non-performance and for which the worker does not offer himself voluntarily. However, the ILO forced labor indicators, the 11 indicators that we saw just now, will still be used as a guidance. So here, CBP can enforce this through two ways. The first one is the WRO. So that's the one that we have been seen slapped on the companies in Malaysia. The WRO is a withhold release order. So upon reasonable information that is received by the CBP, that indicates that these goods have been produced by forced labor, the goods can be detained and prevented from import into the US. So the provisions on the CBP procedures to detain or seize can be found in the Act itself, but I won't go through them in detail here. And secondly, here, the second way it is enforced is through what they call a finding. So when the CBP gets conclusive evidence that the goods were made with forced labor, this then results in detention of the goods and a public notice in the US Customs Bulletin and Federal Register. So the WRO and the findings are published in this Federal Register and they can be found online as well. So I'll get my colleagues to share the link in the chat box with you so that you can also check it out. False statements from the importer may also result in criminal prosecution. So this is something that we have to take note of. Next, how do we release the goods subjected to WRO or a finding? So I'm just going to cover this very briefly because Mr. Matthew Thomas Phillip is, I think, going to go into this in more detail and also share his experience in lifting this WRO. So here, for example, if you have goods that have been subjected to a WRO, you may then submit evidence, for example, a supply chain audit report within 3 months to prove that the goods were not produced by forced labor. If your goods have been subjected to a WRO, you may also then re-export the goods to other countries within 3 months. If the importer does not submit any evidence to the CBP or lacks evidence, the goods may then be excluded from import into the US under a WRO or seized under a finding. So it's different. So here on the screen, you can see the procedure summary of what I've just said. The CBP first issues a WRO or a finding. This then leads to a detention of goods, followed by submission of evidence by the importer, which applies both to the WRO or a finding. And for the WRO, you may also re-export the goods. And lastly, depending on the evidence you have submitted, the goods will either be released for import or excluded from import and seized. So the California Transparency in Supply Chains Act 2010. So this act requires businesses to publicly disclose efforts to eradicate slavery and human trafficking from their supply chain. So you need to basically say that say what you have done in order to eradicate slavery and human trafficking from your supply chains. Who does this act apply to? So this act applies to retail sellers or manufacturers who are doing business in the state of California with an annual worldwide gross receipt in excess of $100 million US. However, for the purpose of businesses in Malaysia, even if the law does not directly apply to you, if you have any connection to applicable Californian businesses, then you might also be required to supply information to these businesses in order for them to make such disclosure. So these disclosures must be published on the website, their own company's website, or given in written form to consumers within 30 days upon request. However, the Act does not specify how often this disclosure must be made or updated. The 5 areas of disclosure required under this act is firstly, verification, audits, certification, internal accountability, and lastly, training. It's also interesting to note that legally it is compliant for a company to disclose a statement stating that no steps were taken to address modern slavery in the areas above. Right, so now we move on to the UK Slavery Act of 2015. So Section 54 of the Act requires certain organizations to publish a slavery and human trafficking statement annually. So what this statement must contain is steps taken to address issues, if there are any issues, and it must be published within 6 months of your fiscal year end. This act applies to a body corporate or a partnership, wherever incorporated, that carries on a business or part of a business in the UK, supplies goods and services with an annual turnover of £36 million or more. Non-compliance. So what happens if you fall within that criteria, but then you do not comply and you do not report? So the government may then apply to court to force the business to comply with the law. There is an unlimited fine for non-compliance. And the government has also announced that they plan to publish a list of non-compliance businesses in the future. So again, this is an act which applies to companies who are trading in the UK. However, the question here is, why does this matter to you? Because you are in Malaysia. So so similar to the US, it's the same thing. They will have to report on what happens in their supply chain. You, as a Malaysian business who exports to the UK, is part of that supply chain. It means that you will have to provide these companies with information in order to report. So if you do not provide that information, then that company is unable to report and will be subjected to the sanctions which I have just mentioned. So that may consider these businesses to then rethink about whether or not they want to do business with you, because then it is risky for them. So how do you make disclosure under this act? So you need to make this disclosure easily accessible from the homepage of the company website. This disclosure must be approved by the board or equivalent and signed by a responsible member, for example, a director. And if this company has no website, then they need to be able to provide written information upon any request within 30 days. So the UK Modern Slavery Act has recommended areas to cover, but there is no mandatory format that is provided under this act. So you can see from the screen that you need to cover the organization structure and supply chains, policies in relation to slavery and human trafficking, your due diligence processes, risk assessments and management, KPIs to measure effectiveness of steps being taken, and training on modern slavery and human trafficking. So this is it for the UK Modern Slavery Act. We will now move on to the Australian Modern Slavery Act of 2018. Right, so as I mentioned earlier, the Australian Modern Slavery Act of 2018 is relatively new. This is the first year businesses have had to make such disclosure. So what the Act does is it establishes an annual reporting requirement for certain businesses and the Australian government on the actions taken to assess and address the modern slavery risks in their global operations and supply chain. So as you can see, these three acts are quite similar, which makes sense because both the UK and Australian Modern Slavery Acts did use the Californian one as a precedent. So who does this act apply to? It applies to Australian entities or entities who undertake business in Australia in that financial year with a minimum consolidated annual revenue of Australian $100 million. Non-compliance. So what happens if the business refuses to comply with this act? So the government may then publicly name and shame businesses. So as we know, reputational risk is a major risk and could lead to a lot to major financial implications as well. So how do you make disclosure under this act? The disclosure needs to be submitted to the government for publication on an online central register within 6 months of your business fiscal year end. These statements, similar to the UK one, must be approved by the principal governing body of entity and signed by a member of that body. So for example, approved by the board and signed by the director. So next, we will look at the 7 mandatory reporting criteria for this act. So here on the screen, you can see that the first one, you need to identify the reporting entity, meaning the company. Secondly, you need to describe the structure, operations, and supply chain. Thirdly, the risks of modern slavery practices in the operations and supply chains, the actions the entity is taking to assess and address this risk, how the entity assesses the effectiveness of the actions it is taking to assess and address this risk, how the entity has consulted on its statement with any entities it owns or controls, and other relevant information. So in the Act itself, they also provide guidance for other relevant information, and this could include information like, so this is over and above the mandatory criteria. So this could include things like how the reporting entity has supported development of legislation on modern slavery in another country, whether the reporting entity has participated in external forums on modern slavery to help improve awareness about modern slavery in the business community, how the reporting entity has partnered with a civil society organization or industry body to participate in the international or the multilateral fora. So if you look at section 16 of this act, then you can see what else you can also include in your report. Okay, so this is my last segment for this session. So these are some of our recommendations for Malaysian businesses. So if your businesses is bound by any of the laws that I've just discussed, keep in mind the goal of enhancing transparency within operations and supply chains when disclosing this information. Where possible, always supply more information than less. So as a supplier or exporter, even if your business is not directly bound under any of these laws, so I think this applies to most businesses in Malaysia and SMEs who are exporting, you also still need to be prepared upon request of the company that's exporting from you to give information to authorities, business partners and customers that are bound under those laws. So as we have stated earlier already, yes, these laws may not directly expect you to report. However, because it expects the importers to report on what you are doing, you will have to also comply with this. If you don't comply, it means that they cannot comply. And if they cannot comply, they may decide that it is too risky to do businesses with you. So that is why these acts are also so relevant for businesses in Malaysia. There are other companies that may also require clauses in contracts with your business to ensure that you comply with their requirements for addressing forced labor and modern slavery. So for example, they may include in their contract with you a requirement to conduct risk assessments or audits, and to allow external audits to allow external auditors to come in, for example. Also, in providing your disclosure and information, you need to work towards being able to also supply evidence to show that there is no indication of forced labor, human trafficking, or modern slavery in your operations and supply chains. This information could include evidence of business policies and ethical recruitment processes, which are based on international standards. It could be evidence of training that's been conducted in order to enhance ethical recruitment and working conditions in your company. And lastly, it could also be evidence of risk assessments, audits, internal controls, and reporting. Governments encourage voluntary disclosures and statements under the laws, even where these organizations are not caught by the respective laws. This is especially if your organization is a part of a supply chain for organizations that are made mandatory to disclose. So my next slide is going to give you links to some guidance which you can access online. So I know you can't click on this. So what I'm also going to do is we are also going to share these links in the chat boxes so that you're able to go through them yourself. So there will be links for the US, there will be links for the CBP, the Californian Transparency Law, the UK, and the Australian Modern Slavery Act. So if you have any questions for me, please feel free to put them into the Q&A box and I will try to answer them. Thank you very much.
Thank you, Joanne. Very insightful. I suppose it brings home the truth, the fact that there's no such thing as a local company anymore, isn't it? If you're an exporter, then you sort of have to play by global rules, and these are very important markets for us. We thank you again, Joanne. For our next speaker today, we have the pleasure of having Mr. Matthew Thomas Phillip. Matthew is the founder and managing partner of Thomas Phillip Advocates and Solicitors. He graduated with a double degree in economics and law from the University of Adelaide, Australia, and was admitted to the Malaysian Bar in 1992. With close to 30 years of experience, Matthew has counseled and represented domestic and international clients in highly complex and contentious civil and commercial litigation. Matthew is recognized notably for his expertise in achieving practical and effective solutions and has successfully negotiated over 300 settlements during his long career, often involving multifaceted disputes with numerous parties. He regularly advises MNCs and SMEs on litigation risks and represents them in negotiations and execution of strategies. Please welcome Matthew to share his experience in dealing with forced labor laws. Matthew, the floor is yours. Thank you.
Hello, everybody. Good afternoon. I would like to give some personal experience in dealing with a ban, a US ban on a company called WRP, for which I was a lawyer. I'm just going to start with the announcement by CBP. Just give me a minute. Next video.
Our message here is clear. If you are a trading partner that does not abide by and uphold your commitments to end child or forced labor, the U.S. will do what it takes to protect vulnerable workers from exploitation, safeguard American jobs, and create a fair and level playing field for companies and countries that do play by the rules. Our message here is clear.
Next slide.
Our message here is clear.
Next one.
If you are a trading partner that does not abide by the second withhold release order is targeted at disposable rubber gloves produced in Malaysia by WRP Asia Pacific. CBP found evidence of multiple indicators of forced labor. WRP Asia Pacific exported approximately $79.5 million last year in disposable rubber gloves to the United States.
Okay, thanks. I'm going to go back to the right. So that's it. Yeah, thank you. Sorry. The announcement by CBP was made on October 1st, 2019. I just played that press conference, and at that press conference, they merely announced that they're issuing a WRO based on indicators of forced labor, multiple indicators of forced labor, but they didn't provide any real details of what that forced labor indicators were. So at that stage, lawyers in America were engaged to deal with that. And as they dealt with that, the situation at that stage was we had to consider that the reason why this came up was on December 9, 2018, there was an article in the UK newspaper, in Guardian, that highlighted that two companies, WRP and Top Glove, were using forced labor to produce gloves in Malaysia. And that is probably what triggered the information to find its way to CBP. In the case of WRP at that time, there was additional news that hit the news, additional information, and that WRP had failed to pay its workers, and that was in the news. And additionally, the Ministry of Human Resource had brought a case against WRP with regard to the non-payment of wages. On the slides, I have this chronology of what happened. So it was really triggered by a newspaper article in December of 2018. In January 2019, there was a strike in WRP, and that strike was a 2-day strike because they were not paid. WRP was facing financial issues at that time, and subsequently they were summoned. After that, WRP retained a company to conduct a ethical trade audit, SMETA, of the factory. In March of 29, additional complications came in. On June 2019, the Malaysian High Court ordered WRP into liquidation on the 17th of June, which complicated matters even more in terms of the financial position of WRP. Subsequent to that winding of order, the announcement by CP was made in that press conference, which then meant that WRP's goods could not be released into the US market. By that stage, there were a lot of gloves that had already reached US but could not be released. So the American lawyers had to deal with it, and what I want to share with you is how they dealt with it. Number one, they explained the significance, particularly WRP had a particular market share in America, particularly with regard to surgical gloves, which they highlighted. They highlighted the particular unique financial condition of WRP at that stage that caused some of the problems with regard to the non-payment of wages, and explained that position. They explained the newspaper reports with regard to the delay of payment of wages and what actions were taken to remedy that position, and what actions were taken with regard to the summonses that were provided for. The American lawyers also then relied on the SMETA audit and whatever remedial actions. And briefly, I want to touch on some of the things that I can share with you, which ultimately I'm going to make a suggestion. One, confiscation of passports. An explanation had to be made as to why the passports were being kept in a particular place in WRP, and why the workers did not have free and unfettered access to their passports. WRP's position was saying for safety reasons, they were being kept at a place that ensured the safety of the passports. And I think what happened was the CPP was also interested to find out why is it that in accessing that passports, the workers had to get consent from the management in respect of getting the keys to the lockers in which these passports were held. As a result, WRP had to change their practice and and resulted in ensuring free access to the passports. Remedial action was taken for that. The second area that CPP were looking at was the control of workers' movement. There was a complaint that WRP was controlling the workers' movements, that if they wanted to leave the factory, they actually had to clock in and report. And they thought that that was in violation of a code that was considered as involuntarily forcing a person to stay. WRP had to explain that nobody were forbidden to leave the factory. They explained that the timesheets were merely to indicate who was in the factory, who was not in the factory, or at least at the hostel premises, so that they were able to audit who was coming in and out. In any event, that practice was discontinued. There was a complaint about excessive overtime hours. The American lawyers had to explain that under Malaysian law, overtime was allowed provided certain conditions were met. That had to be explained. Then there were issues about employees working on rest days that had to be explained. Remedial actions were taken. Memos were issued to say that that practice were discontinued. There was improper deductions from wages. This pertained to the use of money at the canteen and other deductions, some of which were allowed by under Malaysian law. And so that had to be explained again to CBP. On the matter of delayed wages, an explanation on the financial situations and what are the remedial actions taken were done. So these were being explained. EPF was delayed. Again, that related to the financial position of WRP. Remedial actions were taken by, in the meantime, apart from the liquidation of WRP, which was subsequently set aside by the court in October, there was also dispute between the shareholders insofar as control of WRP, which exacerbated and probably contributed to the problems. But then there were questions of poor living and working conditions that were alleged. The WRP's workers were in crowded dormitories. What happened was that new management came into the picture after the winding up of WRP was set aside in October. A new board was constituted in November by an order of the court. And finally, in January of 2020, January this year, the new board gained access and possession of the factory premises from the previous management. I myself had gone to WRP under authority of the new board. I was locked out at the gut house, not able to go in from November. And finally, with a court order, we went in January of 2020. That was the first time in which I could see for myself. So as I said, the US ban had already been in place. There was communications between the previous management and the US authorities through lawyers. I came in January and I then reviewed the documentation between the previous management and the lawyers, and I got in touch with the lawyers. I personally got in touch with the lawyers. I personally got in touch with the suppliers in America and assessed the situation. When I came into the picture in January 2020, my immediate reaction to this was, why was the US ban so discriminatory? because I felt that in January 2020, the complaints that they had about WRP were common complaints. If I looked around, Top Glove was doing the same thing. Everybody was really doing the same kind of thing. Why was it that the US ban was targeted only to WRP? So my initial reaction was kind of like the Malaysian perspective was, if it's discriminatory and it's a government action that's discriminatory, then I would challenge the US ban. So as putting on a lawyer's hat, my immediate reaction was to ask the American lawyers to set aside the US ban on the basis that it's wholly discriminatory, because the kind of behavior that WRP was undertaking was behavior that was common among so many factories. So my initial reaction was to set aside, try to set aside the US ban through a court process. But the US lawyers then very cleverly advised me that such process would take a long period of time with no uncertainty of success. And the same kind of, that the effort should be focused on actually taking action to address the concerns. And I think the advice was correct. Ultimately, it was not really a legal problem. It's actually, ultimately, I realized it's actually a human problem. It's the problem of WRP looking at these workers as not, and not treating them as humans. And I think that when we looked at it and said, hey, when I went into the hostel and I looked at it and I said, these things need to be improved. One of the things I said to the board is I'm going to spend a night at the hostel, and I had planned it for March, and then the COVID restrictions came in. Well, my point is that all of those problems that WRP was facing was actually solvable if we look from a different perspective. The conditions were not ideal, they needed to be improved. And when we really worked on it and earnestly and genuinely, I realized that actually we could solve all of these problems, and we worked towards solving that. The final problem that we face, so actually make the hostel better, put in a plan in place. There were some ridiculous policies. For example, there was a policy that workers were not allowed to bring in outside food. I thought it was so ridiculous that the moment that we came in, we said, well, that stupid policy needed to stop. So it was actually just a human resource issue of looking at fellow human beings and treating them as such. And once we did all that, or at least started to do that, I know not all of the things can be solved. Some needed money. And given that WRP had financial issues, I think the first thing is to make an honest commitment to make things better. And the moment they did that, the tide changed for WRP. I almost believe that it's like karma. You know, you got screwed because you treated your workers so badly. You got a US ban. Make a commitment to make their situations better. And lo and behold, the last final problem and last hurdle that WRP faced was that CBP really stated they were satisfied with the explanations with most of the things, but it came down to a very big problem for WRP, which was the issue of remedial payments. This relates to the fact that most of, particularly in the case of the Bangladeshi workers, they had paid huge recruitment fees to agents, and they were in this situation where they had to pay back. There was allegations that there were collusions in terms of recruiting these workers. So what happened was CBP said that we had to make good the payments and make good remedial payments. That was the most difficult part, because whilst we could do the others, this part actually required a financial commitment. Finally, in March, through the advice of the American lawyers, they said that we provided the financial position of WRP and got an installment plan paid. But eventually the thing is we had to make a commitment to pay that. And in March 23rd, after we made the final commitment on making sure that we'll make good on the remedial payment, the US ban was lifted. So my answer to this is you don't need a lawyer to solve or to avoid a US ban. You just need to change your perspective. These are your fellow human beings. You treat them well. If you can't send your own children to stay in your hostel, then there's something wrong with the way you are running your factories. So really, it's not a legal problem, it's a human problem. Treat humans correctly and you won't have a problem with a US ban. That's it. I hope that's helpful.
Thank you, Matthew. That was a bit unexpected, I think, coming from a lawyer when you sort of intimate the fact that it's not a legal problem, it's a human problem. That should hopefully resonate with a lot of business owners to sort of relook at the issue in a different perspective. Again, thank you, Matthew. It was very insightful. Thank you for joining us today. Our final speaker for today is Mr. Balan Shanmuganathan. He is the Senior Director for Sustainability at Seagate Technology Malaysia. Now, he has been with Seagate for the past 26 years, starting in the environmental health and safety section. During this time, he had work assignments in Europe and the United States, giving him a global perspective on stakeholder expectations. For the last 16 years, he has been working in the area of corporate social responsibility. In his current role at Seagate, Balan manages the overall sustainability program for the company. He has been actively participating in the Responsible Business Alliance, or RBA, since 2004. For those who are uninitiated, RBA is the world's largest industry coalition dedicated to corporate social responsibility in the global supply chains. Balan has also led and co-leads the RBA's risk assessment work group, which develops tools and processes to conduct environmental, social, and governance due diligence in the supply chain. He has been involved in forced labor issues over the past few years, focusing on supply chain due diligence, capacity building, and remediation. With that, I would like to now invite Mr. Balan for his presentation. The floor is yours, sir. Thank you.
Thank you, Jai. Good morning to everyone. I would like to take this opportunity to thank the organizers to allow us, provide us a platform to share some of our experience from working with our suppliers in the topic of forced labor. So first, just a quick introduction. So who is Seagate Technology? Seagate Technology is a data storage company. We have factories in the US, in Europe, and also in Asia, with about 40,000 employees worldwide. We do have a large part of our supply chain is based in Southeast Asia and specifically in Malaysia. And we are, since we manage our own factories, we are both a supplier and a customer. So we are very close to these topics, as well as live them on a daily basis. The other organization that I would like to just highlight here is the Responsible Business Alliance, otherwise known as the RBA. Some of you might have heard of the Electronics Industry Citizenship Coalition, the EICC, which was the previous organization. We had a rebranding when we expanded the role. The RBA has, which started off predominantly as an electronics company initiative, has expanded to cover automotive, toys, and even retail. And the RBA is basically where the electronics brands have joined together in working together in developing tools and processes and a code for us to manage our supply chain. So it's the issue of ESG and forced labor specifically, it goes beyond what one company can do. You need a collaborative effort. And so we work together with our peers in addressing this through the supply chain. As I go through this presentation, when I make reference to forced labor, I'm basically covering the issue of recruitment fees, withholding of personal documents, and housing conditions. I won't talk too much about housing since we had a good discourse earlier in the webinar. Now, why is it important to brands? Right. So when you look at why is it important to Seagate or any of the big electronics brand, it basically is tied to our corporate values. We are guided by our corporate values in how we want to run our business. Right. And And those who produce components or products that go into our products or carry our name is basically an extension of our footprint. So what we expect is the similar working conditions that is provided to our employees is also extended to the suppliers' workers, because they are in essence producing parts for us. Right, so that's very important when it comes to how we want to run our business and how and the expectation we have on our suppliers. Second is stakeholder expectation. What I mean by stakeholders is our customers, our investors, civil society. When you talk about manufacturing and producing a product, it's basically a whole ecosystem. It's not just one company producing something. We all have suppliers, and we all are suppliers to other customers. So when we look at stakeholder expectation, we need to understand what is it that is important to our stakeholders. And through dialogue and through codes of conduct, we are made aware of what are the topics that are important to our stakeholders and how we need to meet those expectations. So our stakeholders basically hold us accountable for the practices of our supply chain. Right? It's not just managing the Seagate factories, but it's also managing our supply chain. Now, I've put regulatory requirement as the third bullet because that is not the key driver. Because when you look at the two bullets on top, the corporate values and stakeholder expectations, they go much higher than the meeting legal requirements. Right, so legal requirement is the bare minimum that we have to meet, and Joanne covered in detail, the U.S. The U.S. regulations, the U.K. Modern Slavery Act, and these regulations, as what was discussed earlier, require us as brands to disclose. So when we disclose, we have to be very, very transparent in what we are doing internally within our company to manage our own operation, and also what type of programs and due diligence that we conduct on our supply chain to ensure that the supply chain is free of conditions of forced labor. And finally, the other thing that's also an important aspect is ESG ratings. We are rated as companies on our ESG performance. And I've got some examples there of Know the Chain, Bloomberg, and Sustainalytics. Which was initially started off as rating the company on our performance, has now expanded to include the performance of the supply chain. So when they rate Seagate, they don't just rate Seagate on our performance, but also the performance of how we manage and the performance of our supply chain. Now, these ESG ratings, of course, then feed into our customers, our investors. So when investors are looking at where they want to go invest, in which companies they want to go invest, they look at these ratings as well. And this, of course, then gets a lot of attention at senior management level within our own company or within any brand company. So ESG ratings are important because it's a public report card on how we are performing as a company and how we are managing our risks. Now, what do we see as challenges in the supply chain? Understanding the issues and expectations is important. So when we look at understanding issues and expectations, we find that in many cases, suppliers understand the process of hiring a foreign labor worker in the Malaysian context. They're not familiar with what happens in the sending country, in the source country, right? They leave it to an agent. And the agent is supposed to basically manage the whole thing, and then the worker then appears in the Malaysian shores and where they take over, right? Now, what we have found is when we have issues of forced labor and when we start digging deeper and trying to identify the issues, and what was raised earlier as examples, we see a lot of issues in the sending country where workers have paid exorbitant amount of money to get these jobs. We've had situations where agents go and bid or auction out jobs. If it's a reputable company that's hiring, they auction the jobs so that workers pay to get that, to get called for an interview to work at this reputable company, right? So it is very important for us to understand what are the end-to-end process so that you appreciate the complexity, you identify the risks that are involved so that you can better manage this. While I was going through the webinar, there were some questions with regards to passports. We make the general statement that, oh, you should not hold passports of the workers, you should give it back to the worker. And there were questions in there for safety purposes, or can we hold that for security purposes and whatnot. What we expect when we say that the worker should be given possession of his passport or personal documents, it is also expected that the employer then provides the worker with secure storage, lockable cabinets in their dormitories, right? Lockable lockers at work. It does not have to be in their room. It might be a post box type locker in the management office where each one has their own key where they can go and pick up and remove their documents, like a safe deposit box, right? So when we talk about understanding the expectations and understanding the issues, sometimes people say, oh, you shouldn't hold passports. It's not just giving the passports back to the worker, but also looking at it and saying, how do you provide them with secure storage so that it can be properly stored? Right, so it requires an appreciation for the issues so that you can better understand and come up with proper actions to address these. Adequate due diligence. Again, as I said earlier, a lot of it happens, when they talk to the Malaysian agent, they know they have a good understanding. They have controls in place with the Malaysian agents with regards to not collecting fees and whatnot, but they don't extend that level of due diligence down to the sending country. We've had suppliers who tell us that, oh no, I've already put it in the contract. Putting it in the contract is some level of protection, but it is not due diligence on the supply chain. You need to go and understand what it means. You need to understand when you say zero fees, is your understanding of zero fees the same as your agent in Malaysia, same as your agent in the sending country? Right, so when you conduct due diligence, we expect higher level of involvement by the company, looking at audit reports, looking at worker chat groups to see, interviewing workers who have been with the supplier, who come through the supplier in the past to understand, did they pay any fees, so that you have a good understanding of the risks, so that you can better manage and put better controls in place. Effective controls. A lot of times what we see is we have a lot of suppliers who bring the workers in, they put in a zero fee requirement, they speak to the worker. When they come back and say, hey, did you pay any fees? The worker says no, and they say, okay, so I'm good. But after a year or so, when we have an audit, these things come out. And in some cases, the company is surprised. Oh no, they've asked this worker when they first came in, the workers all said, that they did not pay any fees. And so basically the company then says, okay, I've done my job and everything is good. Only to be surprised a year later or 6 months later if there's an allegation from an NGO or from an audit where we have identified that fees were paid. And that's because what we found is because it is a continuous process. The controls are not, they come in, you check and it's done. No, it has to be a system in place for you to continuously engage with your workers. In many cases, what we have found is, why didn't the worker tell the employer on the first time when they were asked and then disclose it to an auditor 12 months later? Right, when they first come in, if they are first timers in Malaysia, they don't know. They are scared. They've been told, don't say anything or otherwise you lose your job. Right, so they need to get comfortable with their employer. There needs to be a trust between the employer and the worker, where the employer has to say that this is our procedure, this is our expectation when it comes to fees. You should not have any fees. Keep repeating that, asking the questions over a period of time for them to finally come out and tell yes, they've paid or not. Sometimes it can take 12 months. Sometimes it comes out in an audit, right, or through an employee grievance system. Right, so the controls have to be continuous. You got to continuously look at how do you better engage. Just because you don't get any feedback from a worker doesn't mean that, oh, there's no issues. You got to probe more. Then finally, of course, when you identify issues, you will have to then develop remediation. As what was shared earlier, a lot of suppliers get very shocked when they see the amount of money that these workers have paid. And the expectation, of course, with remediation is these workers will now have to be reimbursed their recruitment fee so that to address the fee issue. And basically today, if within my own company, we are currently in remediation with about half a dozen suppliers who have got who have identified to have issues of high recruitment fees, highlighted either through an NGO report, either through worker complaints, through audits. And in fact, with the 6 or so that we've been working with over the last year and a half or so, we have reimbursed, or the workers were reimbursed close to 2.2 million US dollars. And that's just the Seagate lines, right? So it's about $1 million over ringgit per company, and they're still paying because they are on an installment basis, because you can't be paying millions of dollars in reimbursement, within 30 days, right? You have to look at it, get your budget sorted out, and for you to go remediate. So remediation is something that has to happen. A lot of people get shocked when they see the amount. I had one supplier who actually said, "Oh, the Bangladeshi workers paid so much. I don't want Bangladeshi workers. I want to send them all back." Our answer back to them was, "You can send them back, but you got to pay them before you send them back," right? So you have to understand. So by understanding the issues, understanding the amount of money that's involved, you will have an appreciation for what kind of resources need to be put in place and how this has to be managed. So when you look at an effective, the elements of an effective program, what are the things that you have to have in place for you to better manage this, to manage your risk? Like any other business decision or program, you need management commitment. It cannot be subcontracted to an agent. It cannot be given to a department and say, go sort it out. Senior management has to understand the complexity of foreign migrant worker hiring process, understand the risks, understand the controls and resources that, the due diligence and resources that are needed to effectively manage this. Because when there's an allegation of forced labor, when we as customers come and speak to our supplier, you cannot say, go talk to the agent. We will talk to the senior management. So the senior management has to understand what the full understanding of the issues and the risks. Capacity building. This is very important because, as I said, as we start on this journey, there are a lot of people out there who don't fully understand what the expectations are. So training is important. You need to understand what all encompasses fees. When you talk to 5 different people, they got 5 different definitions of how they define recruitment fees, right? Should the worker pay for his own passport? Or if the worker already had a passport before I hired him, so do I need to reimburse his passport? Right? So there's so many different scenarios and different questions that come up in the hiring process, right? Or the worker came to the city and had to wait 5 days for him to, to go for pre-departure orientation and whatnot. Who pays for his food? Who pays for his lodging? Right? So these are all different costs that are involved, and you have to understand so that you better appreciate and better manage. So that when you speak and set expectations with your labor agents, you are clear, and they are clear as well. And so there are different ways of accessing training. If you are an electronics company, electronic supplier, if you're supplying to one of those big brands or members of the RBA has e-learning on its e-learning academy, which you can access for free. Right, so there are also trainings and webinars that are conducted by companies that you want to make sure you attend, and engage with your customers and ask them how can they help educate and be clear with their expectations. Sometimes we look at the contract, they say you will comply to the RBA code of conduct, just one line in the contract. You got to go launch that. That'll give you a 4 or 5 page policy or code of conduct, that then gives you a 300-page clarification on what that means, right? So there are a lot of things and a lot of details that you need to understand so that you better appreciate the risk and understand what the expectations are. Due diligence, as I mentioned just now, is very important because the more work you put in the front end, the less the impact will be in remediation. So you can either do, the RBA has a supplementary VAP process, which is an audit, which looks at forced labor specifically, which you can conduct on your labor agent. IOM has the IRIS program they're looking at. There are also trainings provided by IOM, Fair Labor Initiative, and the RBA, which you can go take and understand the program so that you can then see which makes sense for you to adopt. You can also work with local NGOs as another set of eyes to look at, to oversee your recruitment process in the sending country. Controls, as I mentioned just now, doesn't stop when you just get to your factory. You need to have a process in place to continuously engage with your workers through worker surveys, worker grievance mechanisms, worker helpline. Right, the RBA has Swara Kami, which is a industry-wide helpline where workers can call in and lodge a complaint or provide their feedback on their experience, which we can then understand and see how we can address and control. And finally, of course, is remediation. As I mentioned just now, the plan is to do the first four so that you address and you manage or reduce the risk of forced labor, but there might be escapees, and you want to have a remediation process in place so that you're prepared. Right? So if there's an issue, it's not you're not starting from zero and saying what does this mean and what it entails. You need to make sure that you have a process in place so that if you have cases, you can then go through that process and remediate. And there are expectations on remediation. How do you come up with the appropriate amount? Because one of the biggest challenges that you will find is when you talk to these workers on the amount that they paid, they will tell you a number, but there's no paper trail, there's no receipts. So it's you have to come up with a process to validate the information that the worker is giving for you to get comfortable to arrive to a number that is reasonable and reflective of what the worker paid for you to do the reimbursement. So the key takeaways, what I would like to say to you guys is, one, educate yourself, because it's very important for you to understand the process so that you appreciate the complexities of the agents, the sub-agents in the sending country, so that you better understand the whole landscape and the laws that are involved, so that you can that apply, so that you can better position yourself. Implement a program starting from management commitment, educating your team that manages the processes, putting together a due diligence program, establishing controls, and also remediation. And then finally, of course, you have to review your programs and controls, because laws are constantly changing. Expectations are being increased. For example, we talked about the US, UK, and Australian regulation. There is a big one coming up from the EU, which is the human rights due diligence regulation, which we think will come out next year. So there are other regulations coming out. So you always have to stay on top of these, because when you hit when you raise a flag in one country, the other regulators are also looking at those and saying, oh, do we have this supplier supplying into into Europe or into the UK? So you want to stay on top of those so that you are better prepared and stay ahead of upcoming legislation. Thank you.
Thank you very much, Mr. Balan. Very instructive. I suppose in conclusion, essentially what you're saying is that the employers shouldn't and cannot take a very hands-off approach in trying to manage this. They need to be aware, they need to be involved, and the level of engagement has to be a lot deeper and broader than it is currently. Anyway, again, thank you, sir. And with that, we have come to the end of the presentations. Now we move on to the Q&A session of the webinar. First of all, thank you, ladies and gentlemen, all the speakers, wonderful. Can I now request if all the speakers can on their video, so yeah, you can actually see them. right? Yeah. Okay, in terms of the questions, what we have done, is I had a good look of the questions. I think overall we can sort of group them into a few broad categories. There were questions from Facebook, Zoom, as well as other channels related to overtime. There were questions related to passports. There were questions related to accommodation. There were questions related to debt slavery. There were questions related to Act 446, as well as government's reaction and strategies overall. So perhaps what I can do is that I'm just going to go through, according to the sequence of the presentations earlier, couple of questions to all the speakers, according to the area of presentation, so to speak. But I would also encourage all the speakers to jump in if you feel that you can add on to some of the feedback that has been given by the respective speakers who answered those specific questions. If I may, can I maybe address the first two questions to Tuan Haji Muhammad Asri and Tuan Raimi. The first question goes like this. If factory rules and regulations contain a mandatory overtime policy, what are the circumstances under which this would or would not be considered forced labor? So basically, it's actually saying that the factory has a rule and such regulations which allows overtime policies as a mandatory overtime policy. Is that considered forced labor? Jeremy, you got to unmute yourself. Yes, sir.
Okay, we must understand that the employer under the law, if we refer to subsection 2 of section 60A, provide that the employer may request the worker to work more than the normal hours of work, and the specification or circumstances has been provided under that subsection. They are paragraph A until F, whereby the workers may be required to work. As I pointed out in my presentation, that in the event that the workers are required to work more than the normal hours of work, they need to be paid accordingly, okay, according to the formula as provided under the law, specifically at the ordinary rate of pay as provided under section 60I. Nevertheless, the Employment Act also provides a mechanism whereby if there is a dispute with regards to the need to do work more than normal hours of work, the Labour Department may investigate, okay, has the jurisdiction to investigate and to determine whether there is a need to do more than the normal hours of work. So meaning that we will look into whether there are circumstances as provided under that particular subsection, whether it comes under exception A up to F, any one of it. So the current mechanism is still there. So basically, the need to do overtime would be based on the requirement of the employer, and it is subject to the exception as provided under the current law, namely the EA.
Is there such thing as a mandatory overtime policy? Is that an acceptable policy?
Actually, it should not be a mandatory. It should be overtime at the request of the employer based on the needs. Okay, based on the needs. Okay, when I say based on the needs, as pointed out under the circumstances. Okay, we have paragraph A to F of the circumstances whereby the employer may require them to work. So for us, we will investigate and to look into whether there are circumstances which relates to that particular subsection, okay, to determine whether there is a validity to require the workers to work or not. So meaning that we have the decision to ensure that.
Thank you, Jay. Another question, similar vein, so to speak, for this is in regards to passport administration. So basically the question is if workers are issued or the workers request the company to keep and also give consent for their passports to be held. Is this allowable with the provision that they can access the passports at their convenience and the passport are kept at the office securely? Encik Raimi? Yeah.
Okay, but the second question is also for me. Okay, as we know that confiscation of passport or holding of passport can be one of the indicators. Okay, so because of that, employers are advised to ensure the workers have the liberty to hold their passport, or if there is an arrangement. So we talk about a mechanism. There must be some form of mechanism such as safety box. Okay, and that one has been highlighted by one of our notable speaker. Okay, meaning that there must be some form of mechanism whereby the workers can get or obtain their passport at any time. Okay, so the employer must ensure that there is a mechanism exists in the workplace. Okay, because we want the employers to show that at the same time they want to give some form of security, but at the same time the workers also enjoy the liberty, okay, to take their passport at at any period of time.
Okay, thank you. The second question, or the subsequent question rather, is quite straightforward. It's to Ms. Joanne. Essentially, the question is a bit proactive in that sense. The question is, how can IOM help us, Malaysian exporters, or help Malaysian exporters to prove that we did not practice any forced labor element in our factories? So it's sort of it flips the whole question. How do they prove that they are not? Can IOM issue a certification or suggest any reliable and reputable NGO or social auditors that could certify us free from forced labor element? Joanne?
Right, okay, that's a good question. Okay, so IOM cannot certify that your company is free from forced labor. However, what IOM does is IOM has two initiatives. So the first one is called CRESS. So CRESS stands for Corporate Responsibility in Eliminating Slavery and Trafficking. So this is an initiative aimed at employers, suppliers, and for this initiative, we work closely with the private sector to develop guidelines and training for businesses. We conduct labor supply chain mappings, risk assessments, among other things as well. And then we have a second initiative called IRIS. So IRIS is the International Recruitment Integrity System. So this one is a certification, but it is meant for recruitment agencies. IOM is the scheme owner and conducts the capacity building for the labor recruiters in order to get them to certification. However, IOM does not conduct the audits for the certification, and we do not certify. This is conducted by an independent third party. So what I can say is IOM cannot certify you, but what we can do is we can work with you to build your capacity so that you can get there, so that you can work towards eradicating forced labor elements in your supply chains. In the Q&A, I think someone also asked about this. So I have put some links there, so you can also contact us if you would like to learn more. And also, of course, there are other social audits out there which your company may be able to undertake in order to get certified, but IOM does not do that. Thank you.
Thank you, Joanne. The other question was, it goes basically, they've noticed that some companies voluntarily they come up with statements and reports indicating labor and modern slavery practices within their organization. So the question is that a good practice, or would that sort of open up a bigger can of worms for these companies? How does that play out eventually?
Okay, so yes, there are some companies, even though they are not mandated by the laws to make those disclosures, they are doing it. So governments generally do encourage all businesses with enough capacity to make such voluntary statements. And yes, already there are many entities with businesses in the UK, US, and Australia that are already doing this. And the reason why they do it is so that they can assure their stakeholders, their investors, their buyers, their customers that they are a good and ethical business. So this is a way for you to showcase that you are a good and ethical business. Even if you don't have dealings in the UK, US, or Australia, companies in Malaysia can still do that by just doing it on your own, on your website, for example, or on your social media. Some of them are also doing it because their buyers are asking for it, or maybe they're being asked to do it by civil society, their business partners. But I think what we need to also bear in mind is that you need to take into account your own business. You need to see whether you have the capacity to do it or not. But what we need to all keep in mind is that transparency and openness are very much new essential values to have in your business philosophy. So just take steps that are consistent and proportionate with your sector, your capacity, your resources, and size. Yeah, so that would be perhaps our advice. Yeah. Thank you.
So I suppose if you're walking down that path, you would need proper platforms. You got to have a decent website with articulates and puts across the kind of practices they're doing and so on. Because on a minimum, sometimes they don't even have websites and stuff like that, right? Okay, great. Thanks, Joanne. Next question, I think a lot more relevant, I suppose, to Mr. Matthew. The question goes, what can we do to avoid WRO imposition, withhold rulers order? I mean, it's quite a straightforward. What do they do?
Thank you for the question. There is a particular index about the behavior that is expected from the suppliers. And personally, I don't see that there's any difficulty understanding them. I think the main problem is our perspective have to change. Many companies talk about we put our people first. I think if they extend that philosophy, they put have this big statement in front of their management office, we put our people first, but it does not appear to extend to migrant workers. And I think if they just take the view that all our people matters and cares, that's a shift in just the thinking, right? You'll find that none of these index are difficult to satisfy. I mean, we found that firstly, a genuine commitment to make change. We have treated people badly and we have to now change. So I think when I look, how do you avoid it? Avoid it by changing your perspective when we say that people matters, our people are our asset. That includes all your workers, includes your migrant workers. I'll give you one final note. When I went to WRP, I looked at the canteen for the migrant workers and then the canteen for the management was on the top floor. And I wondered why they had to have two different canteens, right? So anyway, the canteen for the management, because we didn't have money, it was closed. But I thought, my idea is, well, everybody go and eat at the canteen for the migrant workers and automatically will solve the problem of the food quality at the migrant workers canteen. So my view is, we start with changing our mindset. And we don't look at this thing, oh, what do we do? They're not robots, they're human beings. We have to treat them well. And there's nothing difficult about complying with this. It's about hard. If companies are making billions of dollars, and I talk about the gloves companies, are making billions of dollars and making a sigh about, this is going to cost us money, I think it's absolutely ridiculous. So I think really you got to change your perspective. None of this is going to be a problem if you do that. It may mean that your profits will just come down by very little, but we'll have a sustainable business. So my answer to this is, again, I think it's about changing perspective and you'll solve the problem. In terms of getting advice, there's so many consultants there who will bridge the gap between where you are now at and where you should be. And the way I see it is that once they see there's a real commitment towards change, the only reason why you can't change today is perhaps a financial issue. But if you have lots of money in the bank, then nobody is going to be sympathetic to your problem of change. Yeah, that's what I'm going to say.
Thank you, Matthew. Now, assuming the deed has been done and imposition of WRO has happened, right? So, how should a Malaysian exporter react to it? What should be some of the basic steps they should do?
I think firstly, get a good lawyer who has experience in dealing with the US ban. I was particularly impressed with the lawyers that handled this matter for WRP. They were practical. I approached it from a legal issue. They quickly reminded me that there's a commercial problem. The legal issue may take years to solve. So I thought that lucky for us, they'd chosen the right lawyers. If the lawyers had told us to litigate, we've been dead. The lawyers said these problems can be solved, work through these problems, get the consultants. And the consultant that was brought on board were good. They were able to say that, look, this is where you're at, this is where you need to be, this is what you have to do. So again, these are affordable things to do. The consultants were not like so expensive. Bring the consultants and they know exactly what to do. Hire these consultants, and in where it's a physical problem, for example, sometimes you're stuck. Let me give you an example. If you're stuck in a situation where your accommodation is less than ideal, and you are in the midst of building a new hostel, talk to the consultants as to how you're going to bridge the period in which your situation not ideal to a situation where you're going to be ideal. Put some markers there. I felt with CPP, I thought it was pretty drastic, but when we walked through with the lawyers, I felt that actually it's about commitment towards change. And so my advice is that get consultants in, get good, if it's an American ban, get a good American lawyer who is practical, who can lobby the change, and get a good consultant. You don't need Malaysian lawyers.
Thank you, Matthew. Thank you for being so impartial, I suppose. Anyway, so we have a couple of more questions. This, I think, will be directed to Mr. Balan. Balan, the question is, I think, because of your perspective, you are a principal, so to speak. Now, since the problem seems to be quite widespread, you as a principal and you have a whole bunch of vendors down you, suppliers, what do you do? Do you cut them off from your supply chain? Or do you try to educate? I mean, how do you approach this? Because there has to be a balance between competency and, I suppose, adherence to such policies.
Yeah, well, first, we don't use any foreign workers in any of our operations. We only have locals. So we work with our suppliers and who use, most of our suppliers have foreign migrant workers in their workforce. When these issues are identified through the various channels, basically our approach, and it has not only Seagate approach, it has been the approach of many companies and my peers, where we basically have to engage with the supplier. I have not seen anybody who has just cut off business with a supplier because there was a situation or an incident where they identified. But we work with our suppliers in trying to resolve this, because just cutting the solution, cutting the supplier would then just result in them losing business and then sending the workers back, and the workers will be in an even bigger position, predicament. So it is trying to drive change by working with our suppliers, educating them, and working with them on the remediation plan to see how much we can push to get this thing moving, because we have, in some cases, we have more influence with the supplier as opposed to regulators, because we issue POs, right? We do business, right? So yeah, we have not cut any supplier off because of them having an issue. It is working through them, with them, in trying to resolve that.
Thank you, Mr. Balan. Also, again, I suppose you have sort of addressed it, but how do you sort of ensure that repeated offenses are taken action? If your suppliers are, how much of leeway do you give them before you sort of take them off your supply chain?
I mean, the first and most important thing is when these situations are brought to our attention and when we start engaging with the supplier, we expect the supplier to be serious about engagement, they have to demonstrate to us their commitment. I mean, if they say, yeah, here, go talk to my labor, go talk to my labor agent, we are not there to talk to the labor agent. We want to talk to management. We want to have the plant manager explain how they want to go address this, what kind of controls they have in place, what would they do to go identify the issues, and then how do we then work towards remediation. So the commitment from the supplier is critical. Of course, if you have a supplier who doesn't respond to your emails and doesn't want to talk to you, then of course you probably will have to take a more high-handed approach. But our experience has been from working with our suppliers, nobody has not said, okay, we want to ignore you and go away, because we do constitute a portion of business.
And this is an RBA protocol, right, which cuts across all members of, I suppose, RBA. I mean, this is how
that's how we have worked in trying to
you have
get
how
this.
many members in RBA again?
I believe there are about 170 or so members.
Right.
And then, of course, the 170 members are the big brands. And, of course,
Right.
each of us have...
This will be the likes of Walmart and...
Yes.
Yeah.
Yeah. And again, it is trying to get this. And sometimes, we also have situations where sometimes you can talk to a supplier and he says, oh, your line might be okay. We are working on focusing on your line. It is not focusing on our line. It is how do you fix your factory, even supplying other customers, right? In some cases, when we have situations where we've got multiple RBA members sourcing from the same factory, then it becomes more easier because we now have more than one person talking to them about this issue, as opposed to engaging on a one-on-one basis. So where we have joint suppliers, we get together and we engage together. Where it's one-on-one, then it's a more difficult discussion, because it's not only our lines, but it's also the rest of the factory, because you cannot say I'm compliant in the Seagate line and don't ask me about the other part of my factory. That's not how it works, right? So to change that, sometimes those will become a bigger, more challenging discussion with the auditor, with the supplier.
So I suppose ultimately it has to be a very holistic approach. They can't treat Seagate separately with their other potential vendors. They have to put it all across, and these sort of practices are sort of cascading down to all verticals, right? As more and more MNCs and large buyers, procurement companies, houses adopting RBA protocols and standards. Yeah. Thank you, Balan. I think there was also a couple of questions on Act 446. There's one particular question, basically in relation to Sabah and Sarawak, right? So how does Act 446 get involved in that?
Well, for the time being, this act is only applicable in Peninsula and also in Labuan. However, currently there are progress in terms of having a similar laws in Sabah and Sarawak. But of course, we have to wait for that to be materialized.
Jai, you're on mute. We can't hear you.
I'm sorry, I was so excited it was ending, I suppose. Anyway, with that, I like to say that we are sort of coming to the end of our Q&A session. But rest assured that what we will try to do, I think the speakers as well, and some of our colleagues at MITI and so on, we will try to address many of these questions that has been posted in FB and Zoom and so on. And truly enough, this engagement will continue. Before we sort of moved on to the next one, I think I would like to maybe call upon all the speakers from Saraimi onwards. If there is a particular message, a key takeaway that you're hoping that the audience will pick up from today's session, what would that be, sir? Saraimi, you can start the session. Thank you.
Okay, for me, I think we need to change our practice, okay? Because if we cannot change our practice, then we cannot achieve decent work. And obviously, without achieving it, the ill treatment of workers will always continue. So please change our way, change it to the right perspective and according to the acceptable standards. Thank you.
Thank you, Jeremy. Joanne,
Hi. So I think my key takeaway would be an extension of Encik Raimi's. The world is changing. There are more countries coming up with their own modern slavery acts. We also have France and the EU, which we did not cover today. Consumers are smarter, they are more well informed. So while you may think that at the moment your businesses are not directly affected and you do not need to comply yet, the fact of the matter is others will and are complying. So if you do not start now, you will be left behind. Eventually, buyers are going to go with the more ethical suppliers who are willing to comply. That's all from me. Thank you very much.
thank you, Joanne. I mean, that is a powerful takeaway. I suppose the competitive advantage will now hinge not necessarily only on production costs and all the tangibles that in the past have given us an edge at the export scene, but today it will be more related to, I suppose, brand building, brand association, stakeholder management, communication, and good practices and so on. Thank you, Joanne. Matthew, if you can kindly indulge us, any key takeaways that you would like the audience to have. Thank you.
My experience with WRP showed that even with limited resources and severe financial difficulties, when you put your heart into the problem, when you genuinely want to make people's life better, you can always find a way and people will recognize it. So my takeaway is start where you are. The past shouldn't determine how your future in the way you treat migrant workers will be. That's what I learned. We can start where you are. You have your financial difficulties. Everybody have it. But if you don't, you will pay the price of it, a bigger price of it. The only other thing I want to say is I think Malaysia has a great opportunity, and I'm grateful that you have this discussion because the future in business is going to be measured by sustainability in the way we do our work. So we are in a place where we have the potential. I mean, we mark ourselves, say, against Indonesia, Thailand. If we make serious inroads and treat our fellow neighbor migrant workers well, we are going to be a center for the world to come and make their goods here. I mean, we can't obviously be the cheapest, but we probably can be a center for sustainable production, manufacturing. And I think with WLP, I learned that even with limited resources, you can start thinking with heart and solve problems.
Thank you, Matthew. I mean, you're absolutely right. I think even within MITI and Madrid, we've realized this, and we have also sort of rolled out many programs. For example, Madrid itself, in 2019, we launched something called Sustainability Action Values for Exporters SAFE program, which essentially to facilitate the engagement of Malaysian exporters to embrace sustainable practices as a business agenda, because we truly understand where you're coming from, where the competitive edge over time, not only from a company or industry level, on a country level, could purely be associated in our adherence to sustainable practices and so on. So this is an opportunity. I think that's why I guess all of us are looking at it rather than a big challenge, right? It's an opportunity that we can sort of reach out and hopefully if more companies get on board, we'll be able to make a difference and create an export competitiveness for us. Finally, Mr. Balan, last but definitely not least, any key takeaways, sir? Thank you.
Well, just that managing migrant workers is an aspect of, it's an equally important aspect of your business, just like how you manage every other aspect of your business. So it requires the focus and commitment from management. Be transparent and work with your customers to understand expectations as the expectations are ever changing with new regulations and requirements across the globe. We are in a global market, so we have to act as such.
Well said, as well. And I suppose there's no such thing as a local company anymore, isn't it? I mean, you're part of the global value chain, and you have to look at global expectations and governance model and so on. With that, thank you very much. We've come to the, relatively speaking, the end of our session. Thank you, everybody. I'd like to take this opportunity now to thank the audience, obviously, for sitting through this whole session. Thank our speakers. Also, of course, yang berbahagia Datuk Sri Nur Azman Ayub, Tuan Haji Asri, Encik Raimi, Ms. Joanne, Mr. Matthew, Mr. Balan. All of you have been wonderful. You've shared a lot of insights, and I trust a lot of the companies would have benefited with the kind of information that was given and the thought process that was shared. With that, I hope this will be start of a longer journey where we can be sure that Malaysia will be able to take up this challenge in a meaningful way and make a difference. And the future sessions will be more on how we can sort of leverage and make better, do better in that sense. But before we go, one last thing, we would like to request from the audience if they can complete the evaluation poll, which will appear on your screen now. Yeah, there it goes. So if you can kindly do fill it up, it's a very useful feedback loop for us so that we can sort of improve the next time around. Once again, thank you everyone for joining us today. Thank you, stay safe, and goodbye.